Hoffer. She is our trust settlement and probate paralegal. So I guess to start with a couple questions, just to give people an idea of kind of yourself a little bit and your experience in this area. How long has it been now that you've been doing trust settlement and probate for?
I've been here with the firm for 6 years.
6 years? Okay. I guess kind of what does a standard process look like for you when someone comes in with, hey, I've got this will or I've got this trust, what do we do? What does that look like when someone comes in?
Well, the first thing we do is have a meeting with the trustee or the personal representative and kind of get a feel for the scope of what needs to be done. Are we going through probate? How many family members? What kind of assets are we talking about? And kind of get a good scope of the work, and then figure out, what the process is going to be. What's the best way to approach it?
Okay. Yeah. So, pretty standard kind of with our normal, first client meetings in a lot of ways is kind of getting to know the family, or if it is a current client of our office, we know the family a little bit at that point. But it's really, this is a complex area that you are not expected to know how to deal with yourself. And so that's why, we have Valerie to help us with kind of getting the family set up for that and really walking them through the process. Honestly, I don't know what we'd do without you sometimes with that, because she's really great with the family members. So really, we just wanted to introduce her to you guys so you guys were familiar with her. But with that, actually, myself and Sarah Kahns, another attorney in our office, are going to be walking you through kind of the steps of probate and the different things we're going to be talking about with personal representatives. So thanks for taking the time out of your busy day, Valerie. So, all right. And just as a reminder to all of you, if you have participated in these webinars before, we do have a Q&A function if you're on the Zoom meeting, so you can send those in and I'll see them pop up as you ask those questions, and Sarah and I can answer them live. And if there's ever anything that's like overly in depth or anything like that, and you do want to come in and talk to one of us about your family situation, or you are dealing with someone's estate, you need assistance, we have an evaluation form where you can mark down that you would like us to reach out to you to set up a time to talk, an initial consultation. And we do not charge for those initial consultation meetings. They are complimentary. Usually they're set up for around 2 hours or so. But it's to give us enough time to really get to know you guys and the situation. So with that, I see in here that we've got, just making sure I'm looking at my meeting correctly. There we go. There we go. All right. So I'm not seeing that Sarah's on yet anyway, but I can get started and talk through a couple things with you guys. Get up my notes here. All right. Probate can be one of those processes that people are really unfamiliar with when it comes to what even is it, what are the steps that I need to go through, things of that nature, and what as a personal representative am I going to need to deal with. So really, just to give you a quick overview of what probate is, if you're unfamiliar, probate is the court process in which someone's estate is divided up in accordance with either their will, or if they don't have any will at all, anything going through probate is subject to the laws of intestate succession, which is essentially where the state of Wisconsin has said, okay, here's how somebody's estate is divided up amongst blood relatives, spouses, things like that. If something is, if they don't have a will at all and they don't have any otherwise designated property. One of the things to keep in mind with probate, though, is that not everything actually goes through probate. So some things, if somebody is intending for their estate to go through probate, may avoid that process entirely. So one of the most common things we see is somebody has a will, and because wills only direct those assets that are going through probate, if something is not subject to probate, then somebody's will might not be followed. So, or those provisions in that will might not actually control those assets. So one of the things that someone needs to be very aware of is if they have on like bank accounts, for example, any sort of beneficiary designation, if they have a payable on death or a transfer on death designation, those are the types of things that if you have a will and you're expecting something to go through and be controlled by the terms of that will, then a payable on death or a transfer on death designation may disrupt that planning, or very likely could disrupt that planning. And I see now that Sarah has joined us. So there we go. We were just going through the payable on death and transfer on death designation. Sarah, I don't know if you have any sort of thing to add, if you have any experience where that has disrupted anybody's will, or like a specific example. I know I've seen it happen before, but
unfortunately it does happen more often than I think people realize, where it becomes an issue. It's not just whether or not the child is trustworthy, or the person, depending on who it is that you have listed as a personal representative, or whether their intention is to do what it is that you want with this money, which is to pay for the funeral. But if you don't designate it to actually go to payment of your funeral through, you can set this up a couple of different ways. You can work with a funeral home. You can work with other agencies that allow you to set up things like funeral trusts. But you are allocating this money specifically to go to pay for your funeral first. And it's only if there is a balance that is left after the funeral is paid for, and we're not talking about estate recovery, where the amount would then go to another person after that. When you're using a POD designation or a TOD designation, payable on death, transfer on death, a beneficiary designation of some sort of an account that goes directly to another individual, that's not part of your estate. So even if you intend that to be that, you are putting that person in the position of voluntarily using this money. So it becomes partly a gift, and it can also create significant disruption if the person is incapable of using it for that purpose. And there are a lot of situations where somebody is not able to use money for something that they're not obligated to pay. So when you're just handing an account over directly to another person, but the expectation being that you had a conversation with this individual saying, this is the money that I intend to pay my final expenses, so I'm going to leave it to you because you're gonna be the person in charge of things after I'm gone. So I want to make sure that you have access to this money right away, because there's a lot of people get nervous about, well, I hear that there's this delay, and so you're not able to pay for things right away. And so I don't want there to be a delay in accessing money for payment of my funeral. So I'm going to designate it to go to this one child who's my go-to person. Well, if in like the year leading up to the person passing, that child or their spouse has had their own medical issues, and now we're looking at a potential long-term care situation, either right then or even within 5 years of that point, or if there is the person themselves has become disabled in some way, if they've been sued, if maybe they owned a business and their business failed and they have a bunch of personal guarantees that they had as a part of their business. I mean, COVID is a great example of how things can definitely go wrong, and how businesses can be impacted significantly by what happens outside of the business itself. So situations like that, you might not be allowed to use the money that was designated to you as a person for payment of a funeral if it isn't specified that it goes through your estate. The money is then applied to your funeral and then distributed to the other beneficiaries. You're relying on the child, basically, or child or beneficiary, to either be in a good position to use it for that purpose, being willing to use it for that purpose. I've also had clients where they were designated a certain amount in order to have payment of the funeral happen from this account. But then when the time came to actually use the money for that purpose, because it wasn't part of the estate, they were able to keep the account and then charge the cost of the funeral to the estate, which was very upsetting to the other beneficiaries. because there was an understanding that that's what the money was going to be used for. But there's no way to force somebody to use that money for something if it's not part of your plan, if it's not part of your will, and if you're not funneling that money through probate and through your will. So when it comes to how things get paid, the funeral tends to be a big one because there's a lot of different things that people do because it's the one bill they know they're going to have. Now, there may be very few other bills outside of that they're, they didn't have a lot of credit card debt. They didn't have a mortgage. They didn't have a car loan. Maybe there wasn't a lot of medical things that happened toward the end, but they know that they're going to have this one large expense, which is the funeral. So being concerned about how that gets paid for tends to be a priority for people. But if you're not careful in how you do it, it can cause a disruption in your family more than be helpful, because there's things that can interfere with it, and it's at the option of the person receiving it. So those two factors don't always lead to the result that you intend.
Yeah, exactly. I mean, it's one of those things where it's not good to leave these things up to chance, honestly, even if the person you're leaving things to is the most, or, you're leaving this account to with the anticipation that they'll pay expenses out of it. Even if they're the most trustworthy person in the world, as Sarah mentioned, things can happen to people out of their control, especially a bankruptcy or due to either medical circumstances or a great example was the sort of COVID related situations that a lot of businesses are going through. But I mean, if somebody is left an account and they're in the middle of a bankruptcy proceeding, they're not going to be able to use that money for anything else. So it's just something where you want to make it available to them as the personal representative, if that's what you're naming them as, or prepay it with like a funeral policy that Sarah was mentioning as well.
I've even had situations with families where this is an issue, and even me sending letters saying this person can't use this money to pay for the funeral because of the situation that they're in. They're legally not allowed to do this at this time. This is not a choice they're making, it's an obligation. It still doesn't alleviate the family members that are upset about it. It doesn't alleviate kind of the sting from what was intended versus what actually happened. Even if that particular beneficiary doesn't have any control over it, it still leads to some kind of rough water for that particular person.
Yeah, especially because if somebody doesn't deal with this kind of thing for a living, I'm sure most people don't understand sometimes that people may legally not be able to give money back. They may take it personally, even though that's not within that person's control to, just give that money up either. Now, one of the things that I think in terms of paying bills in particular that comes up a lot, that even the people, I get this a lot, I don't hold any debt. I never have any sort of expenses that I don't pay off immediately, so why would I need anything to go through probate? What do I have to, have money going there for if all of my debt's paid off? And I think one of the big things that, I raised as an example a lot is final hospital bills and medical bills that somebody might have at the end of their life. Those types of expenses, I mean, you can be the most financially responsible person in the world, but the hospital bill is still going to come due. And at that point, if you've passed away, you can't prepay it off. So there may be a need for the estate to hold some of that money to pay those expenses off. I know that's a really big example, but it can be anything to like final cell phone bills. I mean, things like that. There's a lot of things that people have to pay off or continue to pay off after, or their estate, I should say, continues to have to pay after they've passed. So I know a big one we talk about, Sarah, is like if there's any sort of ongoing expenses with the home, right?
Mm-hmm. So, people like to make sure that bills are getting paid. And a lot of times it's because, they're the person that they're administering this estate for, that was a priority that they had, that they didn't miss payments, that they were on top of their bills. And so they don't want the handling of the estate to be different than how the person during their lifetime, how that was handled. They want to keep that consistent. So, I mean, a financial power of attorney ends immediately at death. So you cannot use a financial power of attorney at that point to pay any bills. So then whose job is it at that point? What role are you functioning under? If you have a will-based plan, it means that you are going through probate, that your intention is that the probate court will be involved in administering your estate. The basic definition of a will is that it's a set of instructions intended for the probate court. So it's the instructions for the judge, basically. So making sure that you understand that the role switches then from, even if it's the same individual, you have the same person as your power of attorney for finances and as the person that you name to administer your will in probate, even if that's the same individual, they now have to function under a different title. So you can't continue using the power of attorney document. You have to then move on to being named as personal representative. And so understanding that you can't just continue paying bills, you have to switch roles into that new one. And that's a process. So there are different versions of probate. There's formal probate, informal probate, and depending on the size of the estate, you can also do something called a transfer by affidavit. So these are all different versions of probate. What we're mostly focusing on here today is informal probate. And that's the version of probate where most things are done by mail. There aren't a lot of court proceedings that you're dealing with. It's submitting and filing forms, making sure that you're crossing all the T's and dotting all the I's, making sure everything is accounted for. The job of the personal representative, they used to be called executors or executrixes if they were female. Now we have the gender neutral term of personal representative. So having been named the first personal representative in the will doesn't automatically authorize you to start using that will to just pay for things, to pay bills. You can't take a copy of the will to the bank and say, I'm the personal representative, I need to start using this account to pay for bills. Unfortunately, it doesn't work that way. Nothing ever happens quickly in court. It just doesn't, just ever. In my prior life, I was a litigation attorney, so I can say that with complete authority. Nothing happens quickly in court. So there is a period of time. Everybody has to be served with notice of the fact that the will is filed, and everybody has to be given the opportunity to view the will, and they all also have to be given the opportunity to object to who is named as personal representative. So this can cause some delays. And so this is where you hear people talking about, well, I don't want that delay. I don't want that delay between when I pass and when they can access the money to pay bills and deal with things. So it's that window of time that becomes a big concern. And so the idea of paying bills right away, you're not using the estate account to do that then. You're using your own account and hoping to get reimbursed from the estate at the time that you are named as personal representative, which can come with another whole host of issues. Because then it looks like you as a beneficiary and as personal representative, if you are in both roles, it looks like you may be allocated a higher level of the assets or more of a share simply because you're getting reimbursed for things that you covered during that period of time where you weren't able to pay bills. You also want to make sure that you're paying bills where claims are being made. There, as part of the probate process, once the court has approved a personal representative to act in that role, they'll issue domiciliary letters, which are the actual documents that authorize a person to act as personal representative. That's the document that the bank will accept and then give you access to funds so that you can move things into an estate account, which is just basically a different checking account under the name of the estate instead of the person's name who had passed away. And then you can start using it to pay bills. But if the first thing you're doing is reimbursing yourself for a bunch of things that you paid, that can sometimes cause a little bit of confusion and sometimes a little bit of disruption in the relationships with the family members, because it can appear that there's a higher amount going to that individual when really it's just repayment of bills. But then there's a lot of requests for receipts and a demonstration of what exactly it is that they're paying for. As personal representative, it is your job to make sure that you are maximizing the value of the estate for all of the people involved, for all the beneficiaries. So you're doing things as efficiently as possible, and you're also making sure that you're maximizing the value of the assets that are part of the estate. So if you are doing a notice to creditors, which happens after you are approved as personal representative, they have a set period of time where they are allowed to make claims. You have to notify any creditors that you know are people that money is owed to, like the hospital or the funeral home, or if you know that there was a bill that was held with like a lending institution of some sort. So if you know that there are debts and you know who they're with, you have to notify them directly. The estate is open, you have this period of time to make your claim. You also do what's called notice by publication. So just in case there's any other debts out there or any other creditors that you are not aware of, this gives you the ability to say, I tried to notify everybody that could have been potentially in a position to have a claim against this estate. The court then has a window of time that it sets where all of the creditors are able to say, this is the claim for payment of my bill. Once that time period ends and the window is closed, the court is not supposed to entertain or reopen other bills beyond that time period. So medical bills can be somewhat infamous for this, where you send in the notification, you know that there's going to be a bill because they were at the hospital, and you tell them, okay, we have to make a claim against the estate. Sometimes people will actively seek out the amount and just try to pay it by going to the hospital and saying, okay, how much is it? I'm going to write this check. When what they should be doing is notifying them that this probate has been started. You have this period of time to make your claim, because it is those claims that will be satisfied by the balance of the estate. And then the remainder will go to the beneficiaries. So it kind of goes back to that obligation as personal representative to do the best job you can and to be as efficient as you can. You don't want to have this window open indefinitely. And if they don't exercise the opportunity, then it is closed for them once the court has reached that ending time period. So you don't want to necessarily pay bills that you wouldn't have otherwise had to pay. And we see that a lot with people just trying to make sure that things are getting paid. If you're using probate to administer your estate, you want to make sure that you are using the probate system. And there can be advantages to using the probate system. This is one of them.
I know.
And then make their claims. No, sorry, go ahead. I've been taking up way too much of the time.
Oh, no, you're fine. No, I know specifically with that kind of example, Valerie, this was maybe a month ago or so, was telling me a story about how I believe it was a hospital or something like that, a medical institution, who it was probably 6 months after that window had closed. I mean, it was months. And they tried to make a claim against the estate, or not formally, but sort of reached out to the personal representative and said, oh, we lost the paperwork. It was on our desk somewhere, but it was, the window had closed. And I know they did back down eventually, is my understanding, because I mean, that was not on the personal representative, that they did not file a claim. Proper notice was given. All of the rules were followed. But I mean, in the end, that's not on you as the personal representative. If a creditor is properly notified and does not come forward, that's on them. So that is a way. I mean, that's one of the things where if you go ahead and pay things without that period of time, as Sarah mentioned, there's sort of that goal to maximize the value of the estate in some ways, and to do that proper filing so that they have to follow the rules too, and then they have to come to you, right? So I know that one of the big things as personal representative too is you'll see just a kind of a add-on to that is when you see people do those direct beneficiary designations to people and they say, oh, I'll give more to them right away so that they can pay their expenses, or they'll just use their share and then get reimbursed. And on top of that, not necessarily being the proper way to do things, it can make it so that if your intent was for the estate to be split a certain way, if there isn't a residuary left at that point to reimburse them with, they may not get the percentage of the estate that you anticipated them getting or wanted them to. So it's not so much that it's, oh, they can't get it back. I mean, maybe they can if there's money to reimburse them with, but there's no guarantee. And the whole point of doing things following the probate procedure with wills is to make sure that everybody is given what you wanted them to, if there's enough in the estate, and that all of the proper procedures are followed. And the personal representative has some added duties and responsibilities on top of just the standard beneficiary, where they have to follow certain procedures. I know one of the things we wanted to talk about today too is when a personal representative, can they pay themselves? And what happens in some circumstances where maybe somebody you have named as a personal representative, are they also a beneficiary, or are you giving them a beneficiary share to try to pay them back? And there are things that they can do through the probate process to actually receive compensation. So I don't know if that was something you wanted to talk a little bit more about, Sarah, of kind of what you've seen with that.
So honestly, this tends to end up in one of two schools of thought. Either we have personal representatives who don't want to pay themselves because they feel like it was their duty to do this for their loved one. It wasn't something that they were expecting to get paid for. Some of them also choose to, rather than be receiving the amount as payment as personal representative, which can be income to the person, that we are instead, because they're also a beneficiary, it makes more sense for them to just receive the amount of their share rather than receiving an additional amount that they're getting paid for, but because they're performing a service in order to get paid to do so, that is performing work and getting paid to do work. So it reduces the value of the estate, whereas they could have not paid themselves and gotten a little bit more. It would still be an equal beneficiary. You don't directly get paid for your service, but there are different ways that you can go about it, but you can't make a decision about which makes the best sense for you and your situation, your family dynamics, if you don't understand what the options are. So again, with personal representatives, they need to make sure that they're maximizing the value of the estate, making sure that they're being efficient with things. There's an unclaimed property list that exists in the state of Wisconsin, where there's just accounts that belong to somebody. They seem to have lost them or forgotten about them. And I can't tell you how many times we've ended up finding sometimes thousands or hundreds of thousands in these accounts that are just unclaimed property, because the personal representative simply wasn't aware that this was an asset in that person's name. There are some assets that are more difficult to identify if they're not keeping regular records, especially if it's not something where they're getting taxed each year as part of their, if they're filing taxes, as part of their income tax return. So it's harder to find. And if it goes into unclaimed property, you need to make sure that you're checking that, so that if there is something there, that you're making sure that that becomes part of the estate and part of the distribution to the beneficiaries as well. So this, again, we want to make sure that we're maximizing the value and making things as efficient as possible. So paying yourself as personal representative, there's a couple different ways to do it. There's no right or wrong way, but there is a way that's better for you if you are serving as personal representative for someone's estate. And that needs to be a conversation that you have with somebody that can give you advice about how to do so. There's also other advisors that you can involve in this process. So make sure that, if you are setting up a will-based plan, that you have information in there about what attorney did they work with, what financial advisor might they be working with, or insurance agent, who are the professionals that they relied on to provide guidance. If the personal representative doesn't know who these people are, it's harder for them to seek help from the right individuals at that time. So paying bills when you're dealing with probate can be very easy if you're following the process. But most of the time we see this sort of piecemeal where some of the stuff happens this way, some of it happens this way, some of it goes through the probate process, and then we're hoping that it'll all equalize out at the end. And that's where, you know, the difficulty lies in all of this.
Yeah. And especially with the advisor part of it, I think that's something that if you are, not yet dealing with a probate, but you may be in, the next 10, 15 years or so, if that's kind of what you're thinking, make sure that you and your loved ones work with the advisors, the financial advisor, the attorney, anybody who, especially the attorney who set up the plan, make sure that they and the financial advisor are working together and in directing those assets properly, because that's where I think a lot of that disconnect can come in, is where the financial advisor and the attorney have never spoken to one another. And, all of the accounts avoid probate, maybe with those payable on death designations, but then there's a will plan and it's intended to go, or at least somewhat go through probate. So that can be solved in advance if the communication is open between the different advisors that you have.
It becomes especially difficult if what you have going through probate comes with cost of on its own to maintain, like property. If you have all the money being designated directly to the beneficiaries, how are you getting money to pay, property taxes and insurance and maintenance and upkeep on the property until it gets through probate? So, where's the money coming from to pay for the filings and that type of thing? So you want to make sure that whatever plan you choose, that you're maximizing the benefit of that plan. So if you have a will-based plan and that's your intended path, make sure that all of your people and all of your stuff actually stays on that path. Because the easiest estate plan in the world to administer is the one where everything comes together in one place. The person that you have named to be in charge of it can use what they need to pay bills, settle any creditors or expenses that they have to deal with at that time. And then what remains is divided among the people that you have named to receive in the amounts or shares or percentages that you have decided. That is the easiest estate plan to do. You can do that in a will, you can do that in a trust, but what makes it difficult is people do combinations of different things that interfere with the ability to gather everything in one place, use it, and then distribute it. And so that's most often what we're trying to help educate people on when we do reviews of current plans for people.
Yeah. And review is a good thing to keep in mind too. I mean, these are the things you want to do take a look at every 3 to 5 years or so at the latest, to make sure that, hey, has anything changed? Maybe this bank bought out my current bank and they now changed all the beneficiaries, which happens a lot actually. So
it does. Justin, did we have any questions that we needed to address?
I have not seen anything come up, but we looks like, we are a little over time. So we'll wrap up here, but just a reminder for everybody who's watching this, if any of this raises any concerns for you or you want a consultation, that feedback form that you'll receive does have a place for you to notify us that you would like us to reach out to you and set up a time to talk with either any of our attorneys or Valerie if it's a probate or settlement related issue in particular. And our topic next week, if you're interested, is our wills versus trusts. So we talked a lot about wills today and how that needs to function, but how does that differ from a trust, and what kind of different planning tools might you use with those different estate plans? So if that's something that, sorry, go ahead.
Also remember that all of our initial consultations are free of charge. We don't charge to meet with you to tell you what it is that we think would be either the right plan for you or the right way to handle it in administration. Once we meet with you, talk through your situation, we can usually give you a pretty good estimate as to what the cost will be, but there's no charge for that initial meeting. We want to make sure that we understand your situation before we start giving you advice or start charging you for things.
Yeah, absolutely. Thank you for reminding to mention that. I would have almost forgotten. So, all right. So, we're, like I said, we're a little over. So thank you for joining us today and listening to us talk about this very important topic for personal representatives to listen to. I hope you all have a very wonderful Memorial Day weekend, and I look forward to seeing you guys next week.
Thank you for coming.